has been in effect unchanged since May 4th, 1981, and hence has been available since then to those who wish to avail of its provisions. These statutes set forth the requirements of age that must be attained and years of service put in to qualify for service retirement annuities. The appellees allow survivors benefits to only those retirees receiving service retirement annuities under section 8119, 8120, 8121, 20.1, but not to 8130A2. The issue presented by this appeal is why survivor benefits allowed only to only those retirees receiving service retirement benefits or service retirement annuities under 4 GCA 8119, 4 GCA 8120, and 4 GCA 8120.1, but not allowed to those receiving service retirement annuities under 4 GCA 8130A2. Question is, why? The appellees have only offered that at some point the appellees determined to label the first three sections as threshold and to label service retirement annuities received under 4 GCA 8130A2 as deferred benefits. This is based on a false distinction that while service retirement annuities received under 4 CGA 8130A2 need not immediately be received upon an employee separation from service, benefits received under the other sections must be received upon an employee's separation from service.
Counselor, doesn't that have to do with the amount of time that you actually served the government of Guam?
Yes, sir. It has to do with, all these statutes prescribe different requirements in terms of service and
Date of
age.
employment. Right. And so the statute that you are retired under specifically provides that there is no survivor's benefit if you do choose to remain with the system, with the fund, right?
Well,
so what is the difference then?
Well,
I mean, for me, I'm reading it as it is clear from the language of the statute itself.
Well, actually, Your Honor, if as I indicated in my written argument, these sections that I just recited to you, 4 GCA 8119, 4 GCA 8120, 4 GCA 8120.1 also do not contain any provision for surviving spouse benefits, and I'll explain in just a moment. Okay, so the problem is that here, let me just start this paragraph over again because
Mr. Guthrie, when I look at 8130, that phrase without survivors benefits, do you think that this is a general term which would include surviving spouse in addition to those who are unmarried survivors? Or?
Well, as you can see from reading 4 GCA 8130A2, the reference is to optional survivors benefits. Optional, and I'll get to that in a moment if you like. Optional survivors benefits are benefits for unmarried people.
I'm referring to the phrase without survivors benefits, and survivor seems to, it can include both.
Well, again, Your Honor, if you look at 8130A2, it makes a reference to optional survivors benefits, and then in a subsequent section, optional survivors benefits are defined as survivors benefits for unmarried people. We are entitled to benefits for married people or spouse benefits. And, you know, actually the section that defines this is
Could the phrase optional survivor benefits that you referenced there also be dealing with the options that are available under 8133?
no, and I'll get to that in a moment. You know, okay, if you look at 4 GCA 8134.
Just so you know, you did more than 5 minutes, so you can still continue.
Okay,
You've had 7 already or
All right.
8.
okay, it'll come off the back end.
All right.
Okay, with respect to optional survivors benefits, if you look at 4 GCA 8134C, it defines optional benefits, and it says optional provisions for unmarried employees upon retirement for services. Any unmarried employees, whether male or female, if in good health as determined upon medical examination, may elect to receive in lieu of his or her full service retirement annuity on a actual equivalent basis, a reduced annuity payable during his or her lifetime, with an annuity payable to his or her designated beneficiary.
I agree with you that that's the only provision where the word optional is used
Right.
again, is in 8134C. But when you look at the question I asked, that 8133 also has some options that are available to a surviving spouse.
Yes, that's correct, Your Honor. And let me just tell you how they are available. 8133 provides for survivors benefits for inactive employees. Inactive employees are defined by the fund zone regulations as employees that have separated from service but are not receiving benefits. So in other words, say, you know, someone works for GovGuam for a while and then they separate and but they're not eligible for, or for whatever reason don't apply for retirement benefits. And if they have put in 20 years and they die, then they can collect for
Survivor
benefits under 8133.
But then if we construe, doesn't that seem if we construe 8130 or 8134A1 as allowing a person who's completed 3 years of service to obtain a spousal immunity upon the death, spousal annuity upon the death of a member, doesn't that somewhat, how do you reconcile 8133 and 8134?
Well,
How do you reconcile that?
well, because they apply to different situations, Your Honor. Like I just indicated, 8133 applies to inactive employees. 8134A2 applies to retirees. Inactive employees being people who haven't applied for retirement, are not receiving retirement, but are separated from the government of Guam.
Don't you think the legislature intended 8134 to talk about the death of a member who's completed 3 years of service to be a person who was in service at the time the death occurred?
8134 only, it applies to 4 classes of people. Number one, people who are in service, meaning that they are working for the government of Guam at time of death. They're actually employed by the government of Guam. It also applies to people who are killed on the job.
Line of duty.
Line of duty, right. Let's see, what was it?
So you said there were 4, but I only saw death of a member, and you're saying that that's a person who's in active
Right.
service. Then you said that line of duty, that's the second
Right.
category. You said there are four categories you
Oh,
feel are
Well,
covered.
actually, there are three categories and the third one is
Your
retirees.
situation.
Retirees, you know, all those who are retired and their spouses die.
So you're a member who's completed 3 years of service, even though you, it would be when you die, you won't be an active member within the ambit of this.
Well, I already am collecting retirement.
Right,
But, you know, my issue is just surviving spouse benefits.
right.
But actually, what's really important here is that that the board itself adopted a regulation. Is kind of, it is misnamed vesting of benefits, where they provided for those who retire after October 1st, October 1st, a certain day or a certain year, that they are that they changed the requirement for 3 years to 5 years for people who retired after October 1st of, I think it's 1990.
Right. So you think that 8133, I mean, that deals with the death is someone who's an inactive member versus 8134 is someone who is, it applies to a different situation.
That's right, Your Honor.
And you don't think it circumvents the purpose of 8133? Because 8133 requires a retired member to complete 20 years of service to qualify for the surviving spouse annuity. And 8134 would only require 3 years for the same outcome.
Well, but one has, like I say, one is a retiree, meaning that they've already retired, that they've already applied for it and receiving retirement.
But how is that consistent with the policy of trying to entice people to remain with government service?
Well,
The purpose to attract qualified employees to enter and remain in government service so the government runs efficiently. If after 3 years you can obtain retirement benefits and then get a spousal immunity versus someone who remains in service for 20 years and then gets a spousal annuity. I mean, why wouldn't everyone just say 3 years and I'm out?
Well, Your Honor, because I'm not advocating the 3-year position. They are the one that says that what I'm advocating is you just work 3 years and you can get out. What I'm advocating is what it says in the statute that I applied for retirement under, which is for GCA 8130A2. I mean, that's their position. It's not our position.
You have about 16 minutes left. You want to reserve?
Yes, please.
All right, thank you. Macho.
Hafide, Your Honors, good afternoon, and may it please the court. Vincent Camacho on behalf of the Government of Guam Retirement Fund. The petitioners asked this court to address two specific issues. Whether a spouse of a member receiving a retirement service annuity under 8130A2 was entitled to surviving spouse benefits under 8134 upon the member's death. And two, whether a spouse of an annuitant receiving a service retirement annuity under 8130A2 was entitled to spouse benefits under Public Law 11-171, Section 5 upon the annuitant's death. The Board of Trustees respectfully requests this court to respond negatively to both inquiries. Petitioner's pursuit of surviving spouse annuity subsequent to his demise runs counter to the statutory directives delineated within 4 GCA Chapter 8, Article 1, which is the DB plan.
Councilor, was Public Law 11-171 passed subsequent to the enactment of the section that Mr. Guthrie retired?
8130,
Yes.
yes, I believe so, Your Honor. Public Law 11-171 was, I believe, signed into law in 1972. 8130 has survived since the inception of the fund, which was in 1950. Thank you, Your Honor.
Why doesn't the 8130 A2 provision to optional survivors benefits reference this optional benefits identified in 8134C?
If I may, Your Honor, the statutory construction of the retirement section is, as Mr. Guthrie stated, if we go to sections 8119, 8120, 8120.1, those determine who is eligible for retirement. They are based upon when you entered into government service. 8119 applies to anyone coming into government service before October 1, 1981. Mr. Guthrie doesn't qualify. 8120 applies to anyone coming into government service after October 1, 1981. Mr. Guthrie doesn't qualify. He came in 1986. 8120.1 refers to anyone coming in after September 1984. That's where Mr. Guthrie falls into. And why is that very important? Because in order for you to get any benefits under the retirement system, you must qualify for retirement, number one. Those are the only three provisions in which a GovQuam employee would be entitled to any full benefits, whether it's reduced benefits, after reaching an age threshold or service threshold. So in Mr. Guthrie's case, with regard to
Councilor, so Public Law 11-171 was passed in the face of the statute that Mr. Guthrie is eligible to retire in. So if the legislature knew that that provision has those limitations, why would you say that Public Law 11-171 does not prevail over the restrictions for spousal survival benefits?
okay, so Public Law 11-171. All that did was change the definition of what 8134 is, right? So if we look at the evolution of 8134, 8134 was codified prior to the enactment of 11-171. What 171 did is it says, upon the death of an annuitant, if a surviving spouse or children survive, annuities shall be payable to them at the same rate and under the same conditions are applicable to survivors of a member whose death occurs while in service. That's what Public Law 11-171 did. It added that term while in service.
But that term's not found in 8134.
Not now, because subsequent law in 2012 took that out. And that was Public Law 31-192, which basically says,
And that's where Mr. Guthrie is arguing that the first clause of that says a death of a member who has completed at least 3 years of total service, that the spouse gets a surviving spousal annuity under 8134A1A, because he says there's no limitation in that clause to death while in service.
that interpretation, Your Honor, contravenes the statutory construction rules with regard to reading the statute as a whole. Because that would totally, as the court alluded to earlier, totally misalign 8133. And if I may,
Well, the legislature has every right to disregard prior law, right? And be more generous, as I'm reading 11-171 right now. It is more
Yes.
generous in definition. It's
that is,
more encompassing.
so the two statutes or the two public laws that changed subsequent to the initial application or the implementation of 8134, which was formerly 4217 under the Guam Code,
Right.
expanded benefits, but only to those members, as the board has alluded to in their briefs and in their arguments, to those members who are in active service.
But the statute didn't mention that. That's the board that is the board's interpretation, but the statute does not say that.
Yeah, so the statute, if we look at the new version of the statute, it says, upon the death of a member who has completed 3 years of total service, or upon the death of a member in the line of duty. But if you go down to subsection A,
Mhm.
eligibility shall be determined as of the date of death of the member, whether in service or in the line of duty or in retirement. Right? So if we separate just the 3 years versus any other classification, that totally misconstrues every other provision of the
What
statute
provision is
because,
that? What section of the law?
so that's 8134.
Yeah, so you said the first part, and then where was the thing that says,
So if you go down to eligible survivor, which is 8134A,
right?
the last sentence says eligibility shall be determined as of the date of death of a member, whether in service, in the line of duty, or in retirement. So the interpretation that Mr. Guthrie is asking this court to take a look at is just that 3 years, right? Because that's the only way he will qualify, because he's not necessarily a full retiree because he doesn't qualify under 8119. He doesn't qualify under 8120. He doesn't qualify under 8120.1. Those are the three eligibility thresholds in order to receive a retirement annuity from the Government of Guam Retirement Fund. When we talk about, and this is very important, when we talk about 8130, the title of that is refund upon separation. Has nothing to do with retirement. That means a member left government service, and the only option they have is either to withdraw their
But
contribution.
also, when we look at 8130, I mean, you said it doesn't have anything to do with retirement? Is that what you just said?
Correct.
But then at the end, it says, the member shall receive service retirement annuity.
Yeah, that's a term described in the definitions in terms of how to compute that annuity, right? So it's a service retirement annuity. The annuity that the member receives is actually based upon the service provided to the government. So in Mr. Guthrie's case, he only had 18 years of service when he retired. So his annuity is only going to be based upon his service provided to the government, which was 18 years. Under that option. I mean, if I may, if we take a look at 8130 closely, and we take a look at some of the facts within this case. Mr. Guthrie started his employment with GovGuam in 1999. He left in 1986. So that left him with 13 years. He wasn't age 60. So if he left at that time, he was not eligible for the annuity because he wasn't age 60. The only option he would have was to withdraw his contributions or leave it in and come back to GovGuam service, which he did in 2003, I believe. And then he reached age 60 upon leaving government in 2007. So for example, in Mr. Guthrie, we talk about 8134. If anything were to happen to Mr. Guthrie between the time he left GovGuam in 2003, sorry.
The later.
Yeah, 1999.
No, yeah.
There's no way Mrs. Guthrie will get a survivor annuity. The only option available is to refund of contributions. Now, here's where 8133 comes into play. If he had 20 years, Mrs. Guthrie would have the option under 8133 for survivor annuity.
The way 8133 is, it was a constant since the beginning of the retirement plan, no? 8133?
Yes,
Do you think that in 2012 with 8134, the legislature decided to be more generous? Or broaden the coverage? Because it's the later statutory provision.
but the later statutory provision did not touch 8133.
The language in 8133 was the same,
Correct.
even when 4217, the predecessor to 8134,
Correct.
was in existence.
So what I need to explain is the sections 8130 to 8133 determine who gets what upon eligibility for retirement. So if I may, 8130 says if you leave Gov Guam and you don't have the years of service, the only option you have is to withdraw your contributions. Unless you reach age 60, then you have an option to receive an annuity. That's not retirement per se. That is an option in lieu of his withdrawal of contributions plus interest. 8131 is a death prior to retirement without survivor benefits. That is for a person in service who's still working but no survivor benefits or spouse or children. 8132 deals with death after retirement, someone who's receiving retirement who doesn't have a spouse and or children. 8133 deals with the death of a member who is inactive but may have over 20 years.
Let's go back to well, go ahead and finish your thought. I want to go back and look at that language we were talking about in 8134.
Okay. So in 8133, the law provides these four statutory provisions, 8130 through 8133. Those determine what the benefit eligibility is, depending upon the status at the date of death or the date of separation. So 8130, separation upon term separation of service, so on and so forth, right? 8134 now talks about survivor benefits. And then I will address the court's question with regard
So if you look at, you were talking about the language in 8134A1, the last sentence, eligibility is determined as of the date of death of a member, whether in service or in the line of duty. And then it's the last clause, or in retirement.
Yes.
So it seems like Mr. Guthrie is arguing, well, he wasn't obviously in, his death didn't occur. He's had the 3 years of service, presumably, that if he dies while retired or while he's receiving a retirement, which is what he has now, his wife should be eligible for the annuity under that language.
But for 8130A2, which says he's not entitled to survivor benefits.
But his argument is that only was intended to limit unmarried individuals from receiving that.
There is no indication in the statute that that's the case. And the reason is because it doesn't make any sense. Because there's only one surviving annuity or there's only one surviving spouse and benefit, and that is the annuity. The only other benefit is the $1,000 death benefit that a surviving spouse.
Right, but there is an optional provision for unmarried employees who can elect, where the retiree could elect to receive a reduced annuity to provide for something to a survivor benefit to an unmarried, his unmarried partner, for example.
That is correct, Your Honor. But if you read clearly what subsection C says, that individual must have been qualified for retirement under 8119, under 8120, under 8101. Mr. Guthrie is neither of those. So what this does is it allows a member to retire and choose only 90% of what he's entitled to, so that when he dies and his common law domestic partner will receive some sort of annuity. Mr. Guthrie is receiving 100% of what he's getting. He didn't exercise any
No, but
option.
he's saying that that's what was excluded from the language in 8130, which says without the choice of that benefit, means those guys don't get that benefit, but it didn't limit his ability to have a surviving spouse's annuity if he retired under 8130 A2 under 8134 A1, because he's saying that he's a member, he's completed 3 years of service, and therefore his survivor is eligible under 8134 A1.
Perhaps if he invoked the reduction of his annuity, he can argue that. Because in order for an unmarried individual to receive part of the annuity, the retiree or the annuitant must receive.
Right, but he's married, so he can't, I mean, that's not a requirement for married persons under 8130.
Right, so that's the optional retirement that he's not entitled to. Right, so that
Right, but
doesn't.
what he's arguing is the restrictions in 8130, where it says without the choice of the optional benefits, means that that's what he couldn't choose. And he said, I didn't choose that anyways. So I met what the statute said, which is I don't have the optional survivors benefits that are in 8134C. I don't have that choice. I understand I don't have that choice, but I still should get a service retirement annuity under 8130A2, and my spouse is entitled to under 8134A. One.
I mean, that argument is novel, but it has never held muster throughout the course of the plan since 1950 for the very reasons that the board has delineated in their arguments in their papers. Number one, it will contravene any other provision and sort of cause havoc with regard to who's entitled to what. That would make someone, the only way he can take anything from 8134 is the 3 years. And he asked that specifically by asking this court to apply the Chevron deference with regard to 2 GAR 3102G, which we know is not the right standard of review. This court has said it in many cases. And so the court has also said in Chargaloff that interpretations of regulations are not afforded Chevron. So the board agrees with that, right? The board understands that. Notwithstanding, 2 GAR 3102 only deals with vesting. Every single retirement plan or system in the world has a vesting. And all the vesting does is it determines when someone has a right to something in the plan. So prior to 10-181, it's 3 years. Post 10-181, it's 5 years. So 3182 has nothing to determine whether he receives any benefits, and the board correctly cannot.
So, Mr. Camacho, so I was just thinking of what you mentioned earlier. So for the 18 years of government service that Mr. Guthrie did, his wife is only entitled to $1,000. Did I hear that correctly? And $1,000?
The death benefit.
I'm sorry?
The death benefit.
Yes.
The other thing is his wife could be entitled to is any remaining contributions.
So for the 18 years, just 1,000 in benefits. That's it.
Yeah, that the death benefit is a separate and
Uh-huh.
doesn't have anything to do with service. It's just a death benefit. It's like an insurance.
Well,
Policy.
your argument is that she's not entitled to the annuity, right? The surviving spouse
She's not
annuity. So
entitled to the
it's
surviving.
zero. What
Correct.
other benefits are there other than the 1,000 that you're referring to?
There are none. It's the annuity, the surviving spouse annuity, and the $1,000.
Okay.
But in order for anyone to get those benefits, they must meet the
Thresholds, there are some
80.
thresholds.
Correct.
So that's what the legislature wanted.
Oh, yeah, and it comports to the purpose of the fund, right?
Mhm.
As Chief Justice alluded to earlier. The main purpose of this fund, it was to attract and retain.
So under 8134, the legislature didn't want to be generous to surviving spouses. That was not the intent in 8134. Just a
Yes.
terms.
And
And
I think, and I can't speak for the legislature, obviously, but if we take a look at the evolution of 8134, 8134 was always meant to provide surviving annuities for members who are in service or die, right, while they're serving or while in retirement. So in order for you to qualify for retirement to get your survivor annuity, you must comply or meet the thresholds of 8119,
yes,
8120, and so forth. It's very important to understand why 8130A or 8130 in and of itself stands alone. Because that's sort of the catch-all. If you don't have 20 years of service with GovGuam, such as Mr. Guthrie, you only have two options
yes. that is-
On separation.
Mhm.
upon your termination of service.
Yeah.
The alternative is, as what Mr. Guthrie did, is he left everything in there, came back to service, increased his service, and therefore was able to go from 13 to 18 years and receive, but still did not meet the threshold of 8133, which if he stayed in 2 more years, we wouldn't be here today, whether he's inactive, because if he was inactive. But to take the argument that Mr. Guthrie makes, it's a contortionist type of backdoor attempt to get survivor annuities. And he has a right to do that, but that's not what the plan calls for. So I think it's important for the court to, rather than focus on the rules of statutory construction adopted by this court in Mina 32 na legislatura en Guahan, which basically says we take a look at the plain language. If there's some ambiguity there, then we need to look to the legislative history in order to ascertain legislative intent. In determining legislative intent, the statute should be read as a whole, not just in a vacuum for certain sections.
You asked us, I noticed that at the end of your brief, you asked the court to look at the plain meaning, but during your arguments, you said that there's ambiguity. I don't
Yes,
understand.
and we would concede, similar to what the Superior Court found, was that the term member is ambiguous as to Mr. Guthrie situation, no one else. Right, because they never, the term member, as he argues, could be anybody. Although if we look at the definition of the term member in 8104D, it specifically says.
So it's not the plain meaning that you're asking us. You want us to look into the legislative intent and all the other factors.
Yes, and unfortunately, the plan has evolved since 1950 with various machinations of different legislatures. And so that's why it's very important to read the statute as a whole and not just look at different sections to pick and choose what applies to me and what doesn't apply to me. Because if you do that, we're going to have a retirement system that in this case, there would be no need for 8119, 8120, 8120.1.
Why do you
Because
say the definition of a member only applies to Mr. Guthrie's situation, the ambiguity? Why wouldn't it apply to others who have completed at least 3 years of service and started getting retirement benefits?
And started what, Your Honor?
Getting retirement benefits.
Because someone who only has 3 years of service cannot get retirement benefits under 8119, 8120, or 8120.1.
So how was Mr. Guthrie able? It was to get the.
The only way Mr. Guthrie was able to get benefits is he had to separate from GovGuam. He had to have less than 20 years of service. He had to be age 60.
No, but you're saying that whether the term member applies to him or not. Or, you know, that you acknowledge that it's ambiguous as to whether it would apply to him.
Yeah, so if we look at the definition of member, it wouldn't apply to him, right? But again, it doesn't specifically rule him out either. And so that's why we can say that because the term doesn't specifically give credence to his specific situation, it could be deemed ambiguous. And by that, we asked the court to look to the statutory construction rules, which says the next step is to look at legislative history and therefore legislative intent. And that's important when you're looking at the retirement statute that's been a statute. So it's sort of different from current retirement plans, where retirement plans now have plan documents, right? The statute says the legislature allows GovGuam to establish a retirement system. But those plans get promulgated in a plan document. In the past, this is GovGuam's plan document, the statute. And so you need to look at the statute as a whole with regard to how you apply specific provisions. So, Your Honor, I see I have 2 minutes left, and I believe you touched on everything other than with regard to the Chevron deference, which the fund has argued is not warranted in this case. Mr. Guthrie has never brought that up at the Superior Court level, or even brought this. This is the first time on appeal that he brings asking the court to invoke the Chevron deference. The Court in Port Authority of Guam and in Chargaloff have held otherwise and has only applied the Chevron deference in one other case in GovGuam, and that is with regard to San Miguel v. Department of Public Works, which deals with the legislature actually giving the Department of Public Works the deference to determine what is legitimately reasonable with regard to determining where the landfill should be. So in conclusion, Your Honor, there's no further questions. Thank you for everything. The Superior Court found that the inconsistencies and ambiguity in the retirement fund statute can be resolved by looking at the articulated intent of the legislature and considering the language of the statute as a whole. Petitioner's interpretation of the statute will lead to absurd results and frustrate the intent of the legislature. The retirement fund respectfully requests this court to affirm the Superior Court of Guam's decision denying the petition for peremptory writ of mandamus. Sizuas Masi.
You.
Mr. Guthrie, your position seems to advocate that an employee could be employed for only 3 years, leave government service, go work somewhere else and be entitled to a survivor. Their spouse would be entitled to a survivor annuity.
No, that's not true, Your Honor, because in order to be entitled to a survivor's annuity, the employee has to either die during a term of service for GovGuam or on the job. And of course, if he worked more than 3 years, but then left and went someplace else, he would not be dying on the job. He would not be dying during the term of service. So he would not be eligible for the supposed 3-year qualified.
So why doesn't that apply to you?
Well, because I applied under 4 GCA 130A2.
Right, but you applied under 8130, but you're asserting that you're entitled to survivor annuity benefits under 8134A1, right?
Yes.
Right.
Well, 8134A1, yes,
Yeah.
yes, that's correct. But, you know, as I indicated in my briefs extensively, although, you know, I believe that what you just heard is sort of a convoluted, um, version of these statutes. You know, in my briefs, I set forth a comprehensive explanation of how all four of these sections were linked by 4 GCA 8134, the statute that authorizes payment of survivors' benefits by definitions and words in common. The relevant legislative history shows that these definitions and words of common have linked the aforesaid statutes over the years in spite of changes in the link statutes and even in the statute serving as the link. I think that's the heart of my argument. Also, I would like to, recognize Your Honor. What's your name? I'm sorry.
Justice Enos.
Justice who?
Terry Enos.
Oh, Justice Enos, a moment ago you said that, or you indicated that you thought perhaps that we were eligible under PL 11 dash 171 section 5. That's exactly right. When I heard that, I say, you've got it. You've got it. That was one of the, that went into effect August 30, 1972. That's when our eligibility under that statute started. And that statute was only repealed in 2012 after I retired in 2007. So 171 section 5 is enough for us to claim surviving spouse benefits, although I made other connections between sections.
But I thought that the section 5 says that death has to occur while in service.
That's right. So if, to your example, said that what happens if somebody put in over 3 years of service and then left Guam and died? They wouldn't be eligible because they have to die during service or on the job. They wouldn't be eligible. It would be impossible for them to be eligible because they didn't die on the job, they didn't die on the job or while in service.
Am I hearing this correctly? But you were not in service.
What's that?
You were not in service post 2007.
That's right. But I did not apply. I applied under 4 GCA 8130A2, which provides for 5 years of service. Like I said, my contention is that the 3 years of service only applies if the death occurs on the job or while in service. Okay, if I may, there's been a lot of discussion about this 3 years, and I'd just like to read that statute for you, because that's one of the hearts of this argument. Okay, 2 GAR 3102G provides in relevant part, persons who joined the fund after October 1st, 1981 are required to accumulate at least 3 years of credited Gov Guam service to attain vested status. The minimum requirement for a person who joined the fund after October 1st is 5 years. So for all for the purposes of this action, the 3 year requirement does not pertain to eligibility for service retirement benefits. To reiterate, 2 GCR 3102G clarifies that those who have separated from service and elected a deferral of benefits, such as those retiring under 4 GCA 8130A2, can retire with only 3 years service. That's the key. Instead, 2 GAR 3102G clarifies that those who have separated from service after October 1st, 1981, and elected a deferral of benefits, such as those retiring under 4 GCA 8130A2, must have at least 5 years of service. In fact, if in fact the reference to member in the preamble of 4 GCA 8134 was ambiguous with regard to whether member applied to those who have separated from service and elected a deferral of benefits, such as those retiring under 4 GCA 8130A2, 2GAR clarifies, no, 2GAR 3102G clarifies that such persons are members. So that's one of the key sections. That was their own regulation. So let's see, how much time do we have? Do you have any more questions?
6 minutes.
Okay.
I have no other question.
So when you separated for in 1999 after 13 years of service, you obviously served more than 5, served more than 3. And you had the option of receiving a refund or leaving your contributions in the plan and receiving a retirement annuity at age 60. And your option was the latter option, right?
Right.
And when did that kick in? When did you start receiving the retirement annuity?
Okay. I started receiving it on May 31st, 2007.
But you had already come back into service in January 2003, and then it was after you separated again in May 30 that you started.
That's right.
That you started doing.
Well,
Okay.
actually, I made 60. I made 60 in 2007, which is when I retired.
Right. But you also ended your employment with the AG's office at that time.
Yes, sir.
And that's when you retired on this service retirement annuity effective under 8130A2.
That's correct.
Right. You have 5 minutes remaining. Are there any additional questions?
I have no other
Any
question.
questions? So if you have nothing further,
Well, let's see. Let me just quickly look here. Okay, with respect to with respect to Chevron, okay, what we're claiming is that Chevron deference should be accorded to that section that I just read.
the GAR.
Yeah, the GAR section. That's what we're saying. And I think,
But isn't that dealing with vesting?
well, I think what my opponent was referring to is there's some language in one of the cases that says that Chevron deference does not apply to definitions of, I mean, like if you have a regulation that defines a term, it should not be accorded Chevron deference. I recognize that as an argument. I don't know how the court wants to deal with it. I think that the definition of vesting is not exactly what you would call a definition in the usual sense of the word. It's, it contains a lot more substantive law than the usual definition of one word that just says, sky is blue, or, I mean, this has a lot of substantive law. So I would say that in this particular instance, because it does contain substantive law, that Chevron deference should apply to that term, to that definition of vesting. Okay. Okay, I hope your honors, kind of slow down a little bit and read my legislative history. I know it's a little dense there, but I think that if you read that slowly, you'll be able to appreciate what really happened over to this matter over the years. Okay, that's all I have. Thank you.
Thank you, Mr. Guthrie. Thank you, councils. The court will take the matter under advisement and will now stand adjourned.